Welcome to Court Explainer from Court Helicopter. First, we wish to pass our condolences to our IT person, the IT manager Lewis Msonga, who passed on in a grisly road accident that killed very many teachers at Ngara, and Lewis had to be in the hospital at Aga Khan for more than 10 days, but he passed on. May the family rest and have our condolences. And the viewers of Court Helicopter, we sincerely apologize that out of that mishap, we had to pull out from airing the clips and allow the family and crew that were working with the late Lewis time to take heart and to come to terms that Lewis Msonga is no more. 2, we are dealing with an explainer that looks at the politics of the day. We know very well this weekend and the next weeks to come, serious issues, political questions are coming. Is Edwin Sifuna, the senator of Nairobi, going to be tear-gassed as he lands at a Malemba Stadium in Kakamega? Will the rally be allowed? DCP, together with the united opposition, that is Kalonzo, Matiang'i, Rigiji, and others, have started a rally today at Eastlands, at Embakasi. Will they be stopped? Next week, they are heading to Nyamira and Kisii for 3 days rally. What is the law that deals with political rallies and public rallies? We have a 2 segment giving why it is unconstitutional to stop Sifuna, Babu Owino, and the rest from holding the rally. In the second episode, we shall provide for what the Public Order Act, especially Section 5, provides for. We have heard the OCS, we have heard the regional police commander say that nobody has gone to give him a notice of that rally. So, in confirming that any attempt to stop Edwin Sifuna from holding a rally is against the law, we shall be relying on the following constitutional provisions. That is Article 29, Article 32 talks about the freedom of conscience, the freedom of one's belief, and the freedom of one's opinion. All these opposition figures are going to associate freely with their followers. And therefore, as I've said, Article 32 allows them the freedom to engage with anybody. What does the Constitution move on? Article 33 provides for the freedom of expression. Hate Sifuna, hate Babu Owino, hate Gachagua, hate Matiang'i, hate Kalonzo. All these people have the right to express themselves. So you cannot stop them on how they express themselves. Free. Article 35, the access to information. The public have a duty and have a right to access information. Remember, they are moving around selling their manifestos. You cannot stop them from telling the people what they think about. Then we have the freedom of association. Can you stop Rigiji from associating with his cousins? You can't. Can you stop Edwin Sifuna from going to Kakamega? Remember, he was born in Kandui in Bungoma. That is his home neighboring county. Can you stop him from going there? Can you stop Babu Owino from going to meet his people? You cannot. Can you stop Matiang'i from going back to Gusiland? You cannot stop that. That is under the freedom of association. Then Article 37, they are going to demonstrate, they are going to picket, they are going to give memoranda. Article 47 gives them the power to assemble, to demonstrate, to picket, and to petition. All these are found in Article 38 of the Constitution, the political rights. You cannot stop the political rights. Every Kenyan has a right to exercise his political rights, either through demonstrations, either through voting, either through picketing, either through attending political rallies. Therefore, that has got to proceed. Let us look at this question. Has this question about the right to hold political rallies ever gone to court? Yes. We start with the famous case. It is here. We have shown you what is called constitutional petition number E327 of 2020. Justice Murima, who was a judge and who is now a commissioner of the JSC, has put in the case of the Law Society of Kenya versus the Attorney General and the Inspector General of National Police Service. That is case number, petition number 327 of 2020. The judge has said you cannot at all stop a political process. This was a case briefly during the COVID time, when the National Police Service and the Cabinet gave a blanket resolution that you cannot hold a public meeting under COVID. What did the learned judge say? The learned judge gave the following declaration. A declaration be and is hereby issued that all directives made by the National Security Advisory Committee on the 7th October 2020 and ratified by the Cabinet on the 8th of October 2020 for the use of Section 5 of the Public Order Act, Cap 56 of the Laws of Kenya, to contain, restrict, and prohibit public gatherings, meetings, and possessions in the name of combating COVID-19 and containing the weaponization of public gatherings are unlawful, unconstitutional, and in violations of Article 10, 2A and Article 245, 2B and 4 of the Constitution for directing the law enforcement officers on how to discharge their duties. 2. The learned judge issued an order of certiorari where he set us off that order. And lastly, he issued an order of prohibition restraining the Inspector General of Police, whether by himself or any police officer under its command, from taking directives from the National Security Council. So this is the first decision that we are dealing with, Section 5 of the Public Order Act. This question was taken during the Gen Z demonstration, where Justice Thande was faced with that question again. The parties in this case, it is at the High Court at Nairobi Milimani Law Courts, the Constitutional and Human Rights Petition number E009 of 2024, where Justice Mugure Thande in September 30th, 2025. This is a case that was filed by ODM. It is Saitabao Ole Kanjori, the petitioner, versus the Inspector General of Police and the others. What did the judge say in that act? Very, very interesting findings by the learned judge. And this is about the riots that occurred when the finance bill was there. The learned judge said, the learned judge found out the following, and this is what the learned judge said in his: a declaration is hereby issued that the use of water cannons, if water cannons are going to be used in Edwin Sifuna rally, a tear gas, a live ammunition, and rubber bullets, and the deployment of brute force or any form of violence against persons exercising their constitutional right to protest is illegal, unconstitutional, and unacceptable in an open and democratic society like Kenya. So, what does the judge say? Any use of brute force against Sifuna, that is Edwin Sifuna's rallies, any use of tear gas, any use of water cannon, any use of any rubber bullets, or any live ammunition is illegal and unconstitutional. That is Mugure Thande that has put that very clear. Lastly, he says, any killings, and if there will be any killing in Sifuna's rally, any arrest in Sifuna's rally, any abduction in Sifuna's rally, any detention, any harassment, any intimidation, any torture, any cruel or any inhuman or degrading treatment of persons who shall be attending Sifuna's rally in Kakamega, Rigiji's rallies, and Kalonzo's rallies in Embakasi, or any rally in this country, they will be held that they have contravened the law. You now know the law. Lastly, this is another decision from the High Court. This is in the Constitution and Human Rights Division, petition number E373 of 2024, Justice Bahati Mwamuye. Who are the parties? The party is still the Law Society of Kenya and the others versus the Inspector General of Police and the Attorney General. What does the judge, Justice Mwamuye, order? Justice Mwamuye issues the following orders. 1, a declaration be and be issued that the proposed limitations of rights to exercise Article 37 in the subject area was a blanket, omnibus, and overly broad one, and thus it did not meet the requirement of Article 24. So anybody stopping Senator Sifuna's rally in Kakamega, that is an blanket stoppage. It is illegal and it contravenes Article 24 of the Constitution. So he moves on to say, a prohibition order be and is issued restraining any police officer or any other person acting under this direction, control, and others, 1, from taking an action to obscure their identification. All police officers who will be at the rally of Sifuna must not hide their identification. 2, all vehicles that are going to be used, the registration vehicles, the DCI vehicles, must have their proper registration numbers in those rallies. 3, or any markings of any motor vehicle being used when in any way dealing with any person who is also planning or assembling, demonstrating, or picketing. So the judge is saying everybody must ensure that they do not hide their faces, they don't wear bravados, and they have got to do what they are allowed. What is the import of these decisions? What Danson Omari is telling you, the law does not allow the police to stop any rally. We will be dealing in the second episode where the court has dealt with how to interpret the law in section 5 of the Public Order Act. But as it is, you cannot stop Sifuna's rally, and if you stop that rally, that is a violation of the constitutional provisions as provided for in Article 37. From Court Helicopter News, we know people have different political inclinations. Our job is to tell you what the law is. The law provides that. Kenyans spoke very loudly in Article 37 that they can protest, they can demonstrate, they can do anything so long as the peace. What about the question of the police arguing that these people are likely to demonstrate and destroy property and injure? The judges have pronounced themselves that the role of the police is to ensure criminals don't infiltrate the demonstrations. The National Police Service's duty is to ensure the demonstrators continue with their demonstrations without hindrance. So if criminals join, the police must, 1, protect the demonstrators, 2, ensure the safety of the demonstrators, 3, ensure safety of the property where they are demonstrating, 4th, remove the elements that are hell-bent to destroy property, arrest them and charge them to court, and lastly, that the police, although they are saying that they are supposed to be notified, the courts have said there is no need. This is a constitutional provision. The statutory provision that we are going to deal is inferior. And the judges, all the 3 judges have said it is unconstitutional. You cannot limit constitutional rights through what we call a statutory right. From Court Helicopter, we wish Edwin Sifuna, we wish Babu Wino, we wish Caleb Amisi, we wish all the people who are organizing Governor Orengo, the moving constitution, wishing them and all the best as they continue their rally. For those ones who are in Nairobi, we wish them, that is Rigiji, we wish Kalonzo Musyoka, we wish Senior Counsel Kalonzo Musyoka, we wish Wakili Wamalwa, we wish Matiang'i and everybody the right to express their views. But this is not the position, the official position of Court Helicopter. Our official position is that the law must be followed and the law allows them to conduct their political rallies without interference with the state machineries. Keep watching and don't miss the next episode that also, according to this law, it is illegal to conduct those rallies. We shall be looking at the second version of the law. My good crew, Bramwell and Cyrus, tell me we need to be balanced. We give the law on one side that allows Sifuna to do the law, then we give the law on the other side that doesn't allow Sifuna and Rigiji to hold their rallies. Happy weekend. Thank you very much.